Happy Constitution Day. It is really quite thrilling to see so many people here today to commemorate the Constitution. I'm Verna Williams. I'm the Dean of the College of Law, and I'm delighted that you are here today. Each year, we mark this important milestone by inviting the nation's leading scholars, practitioners, and judges to give a college-wide talk. We're able to do so thanks to a generous gift from alumnus Lewis Katz, who established the Alfred B. Katz Constitution Day Fund in memory of his father, who also was an alumnus of the College of Law. So please join me in thanking Lou Katz. Now this year we are departing from tradition a bit by having an interactive discussion with Melissa Murray, who's to my right, the Frederick I. and Grace Stokes Professor of Law at New York University School of Law. So first I'm going to give you some background about Professor Murray and then on to the format for our discussion, and then we'll just jump in. Professor Murray teaches constitutional law, family law, criminal law, and reproductive rights and justice. Her research focuses on the legal regulation of sex and sexuality. Her most recent book is Reproductive Rights and Justice Stories. Professor Murray, there's someone calling.
It's my mother-in-law who hates when I tell people that I work on the legal regulation of sex.
Okay.
So she's like, stop talking about it.
Okay. Professor Murray has received numerous awards and honors, and her writings have appeared in a range of legal and lay publications, including the Harvard Law Review, the Yale Law Journal, the New York Times, and The Nation. Prior to going to law school, Professor Murray worked at Procter & Gamble, so this visit is a homecoming of sorts. Professor Murray also co-hosts a podcast entitled Strict Scrutiny, and the website describes it as being about the Supreme Court and the legal culture that surrounds it. It's available online and wherever you get your podcasts. I invite you to listen. So to get our discussion rolling, I will ask Professor Murray some questions, and then I'll invite you all to participate. So the first question, Professor Murray, has to be about strict scrutiny.
Well, first, thank you for having me. I'm so excited to be back in Cincinnati, and thank you so much to the Katzes for their generous sponsorship of this. It's a terrific event, and it's so nice to be here and to see the exhibit of the constitutions outside and like really celebrating what it means to have a written constitution in such a tangible way. So thank you. And many, many thanks to Jenny Edelstein in the Dean's office, who has worked tirelessly to make sure all of this has gone off seamlessly. So I appreciate all of the hard work. Why a podcast about the Supreme Court? Why strict scrutiny? Let me first say, I occasionally get asked by the leading journalists, like at the New York Times and the Wall Street Journal, to comment on the Supreme Court, but it's usually only about things that my husband calls lady topics, things that deal with gender or abortion rights, whatnot. And I actually know more about the Constitution than just that. And so I was talking with other women who are in a similar situation, like, do you only get called about abortion or about Ruth Bader Ginsburg? And they're like, yeah, we only get called about Ruth Bader Ginsburg. And so a couple of us were like, we're experts on the Supreme Court, but we don't get called for all of these things. So we have things to say, we have ideas about it, so why don't we just go out and start telling people what we think about the court? So we're like, okay, well, we can't just tell people. We have to have a platform. Let's make a podcast. So the iPhone is the most democratizing element of the modern age, and so we decided we were going to make a podcast that people could stream on their iPhones or their smartphones, and we called it Strict Scrutiny. It's 4 women, 3 law professors, 1 person who is an appellate practitioner in DC. We have a female producer, and it was sort of, we were going to be women who talked about the court. And we were, more importantly, not going to talk about it in a clubby, insidery way where everyone knows what we're talking about except the people listening. We decided very consciously that we wanted to democratize the Supreme Court. We thought everyone needs to know about what the court is doing. It is so important in our lives. Everyone should know about it. And so we invoke what my husband calls the Aunt Johnny Pearl test. So Aunt Johnny Pearl is my husband's aunt in Meridian, Mississippi. She's 88 years old. And if I can't explain it to Aunt Johnny Pearl the way I'm doing it, then I need to rethink it. And so we try to really make it as accessible to lay audiences as possible because we want everyone to participate in it. So I hope you guys have listened to it. I hope you will listen to it. But our aim is to talk about what the court is doing or has done and to talk about what it means in everyday lives.
Why is it important for people to understand? I mean, why do you care whether Aunt Johnny Pearl understands it?
So I was the first person in my family to go to law school. I did not come from a family of lawyers. I think there are a lot of people at law school now who are in similar situations. I think we call them first-gen students. When I went to law school, we didn't have a first-gen movement. But everyone knows what a privilege it is to be able to talk about the law, to know what you're saying. And you are then asked to sort of translate for people who don't have legal training what that means. So if you go home for Thanksgiving, if you're a 1L, someone in your family will ask you about this, that, or the other legal issue and ask you to explain it. There's a whole legal culture that I think people feel closed off from because they don't have legal training. And I think it's important if you have that privilege to try and explain it to people, to explain what the court means, what the law is doing, and how it impacts their lives. And you know, I walked in here and there's a young woman who's wearing a shirt that says, "My Patronus is Ruth Bader Ginsburg." It's you. There you are. I mean, you're wearing shirts with Ruth Bader Ginsburg. Obviously, the court is part of our popular culture as much it is part of our legal culture, and so we should all understand that, even if we didn't go to law school.
Okay. Well, one of the things we were going to talk about today was constitutional conflict. And as I was thinking about constitutional conflict, I was thinking about, well, you know, how is it the court could help address conflict? And I thought about Chief Justice Roberts when he was in the process of being confirmed. He once likened the role of the court justice to being an umpire.
Or an empire.
Not an empire, not an empire. Umpire, I said umpire. Calling balls and strikes. And I thought, well, if he's right about that, that actually would go a long way to resolving conflict. What are your thoughts on that? Is a Supreme Court justice just like an umpire?
No.
Is that how the court is operating?
No.
Okay.
So first of all, Chief Justice Roberts said this in his confirmation hearing in 2005, and it was widely reported. Like, everyone talked about this metaphor, calling balls and strike. What they don't mention is the other part of this metaphor is that the umpire gets to decide where the strike zone is, right? I mean, so there is a kind of interpretation, even to umpiring, that metaphor completely belies, right? So the Constitution, go out and look at it, it's a pretty spare document for a document that's intended to structure an entire government, right? It is not, as Chief Justice Marshall said in McCulloch versus Maryland, does not have the prolixity of a code. It's not meant to talk about everything or to exhaust every possible scenario. It is purposefully spare. It hits the highlights, but it doesn't go beyond that. And there are lots of terms in the Constitution that are open-textured. What does cruel and unusual mean? What is due process? What is equal protection? There are lots of different terms there that are purposefully subject to interpretation, and that's what judges do. Sometimes they are guided by extant precedents where other judges have stepped in to make a decision about what a term means or how something should be applied. But in a lot of cases, especially at district courts, trial courts, it's a question of first impression, and judges are kind of going it alone, weighing both what the text says, if it's clear, if it is unclear, what a particular interpretation of the text might mean in a broader context. So there's all kinds of interpretation, and Justice Brennan said this in 1980, like, the idea of us as umpires is completely fatuous. We too are a constitutive branch of government who don't necessarily make the laws in the way Congress does, but we make them in how we interpret them. And he was very upfront and bald about that. Like, there is a kind of lawmaking in that interpretive process. We don't like to talk about it, but that is what we do.
Okay. All right. Well, turning to one of the cases that was in front of the court last term, and just sort of in the balls and strikes and what they decide and what they don't decide, the Rucho versus Common Cause case. Now, for those of you who haven't read it yet, at issue in that case was partisan gerrymandering occurring in North Carolina and Maryland. And the question was whether these gerrymandered districts violated the Constitution. And I guess in calling balls and strikes, the answer is either yes or no. But I guess in this case, a majority of the justices said that this isn't really a question that we can decide. It's a political question. And we don't want to get in the middle of that. That's not something that we do. I mean, you've outlined very beautifully what it is the judges do. What's the likely, well, what do you think about that case, one? And two, what's the likely impact of that case on resolving conflict? I mean, we are now in a situation, in fact, talking to some alums, they say our period of conflict that we are in right now is more divided, the country's more divided than it was during the Vietnam War, which is pretty staggering when you think about it.
Yeah. Let me go back to Chief Justice Roberts' remarks about balls and strikes. Part of that, I think, was an institutional competency position that he was establishing. The court is not like Congress or the executive. It is out of politics. It is neutral. It's a neutral arbiter. And I don't think that tells the whole story. The court obviously is part of our political structure. It may be impartial, it may have life tenure and be insulated from the political process, but it's not completely inured to it. When Chief Justice Roberts, in his opinion in Rucho, spoke of a political question, that's a particular constitutional term that refers to a question that is not necessarily political in nature, which is to say it's controversial or it's polarizing, but that it is a question that constitutionally is committed to resolution by one of the two other branches. Either Congress decides this or the executive decides this. And it could be, historically, questions about congressional membership would be considered political questions, things the court can't wade into because they are, by virtue of the Constitution's text, committed to other branches. Political gerrymandering has been an issue that's been around since the founding. The idea, of course, is that you are drawing congressional districts or state legislative districts in ways that purposely favor a particular political party. And the analog to that is racial gerrymandering, which means you are drawing those districts in a way that particularly advantages a particular racial group, or more particularly, disadvantages a particular group. The Supreme Court has said that racial gerrymandering is a viable question for the court because it implicates the 14th Amendment and the 15th Amendment and the whole idea of one person, one vote, right? The question of whether partisan gerrymandering is also a question that the court can take up has been a question that is much more fraught and vexing, and indeed has vexed the court for a long time. So there was a case in 2004, I think, Veith, where the court takes up a partisan gerrymandering challenge and says, we would like to be able to address this, but we don't have a workable standard for determining when a gerrymander goes too far in one direction and becomes constitutionally impermissible. In the term before last, there was a case called Gill versus Whitford, where the court, again, with Justice Kennedy on the bench, suggesting that there was some workable standard, it just not yet had figured out what it was, but that it could in the future. And then, of course, the North Carolina and Maryland cases get teed up. Make no mistake about it, Rucho is the most significant case for the law of democracy in the last 20 years, maybe the last 50 years. Partisan gerrymandering and the way we draw congressional districts is hugely, hugely important, both for purposes of federal funding, if at the state level for the election of judges, for the election of state representatives, it's massively important. And part of the problem is that you have the political branches in these states gerrymandering their legislative districts to favor a particular party. In Maryland, it was the Democratic Party. In North Carolina, it was the Republican Party. And the court, in stepping in and saying, you know what? We can't find a workable standard. We will never find a workable standard. And this is a political question that we cannot resolve and should not resolve. There is no place for the federal courts here. They've basically left it to the political process to resolve. but it's a problem of the political process's making. It's basically like asking the burglar to fix the burglary. And so we have kicked this back to the state legislature, state executive, state courts to resolve. And in removing the threat of federal court adjudication, we've probably removed the last threat of any kind of full stop that the states will have. Now, I think Justice Kagan, in her dissent in Rucho, sounded an alarm. And I think about her dissent there as being a kind of almost demus prudence, speaking to the people through her dissent, where she tells us this is a huge issue. The political process cannot work if it is skewed and distorted through gerrymandered districts, like full stop, it just can't. If we expect to have a working democracy, all parts of it have to work, and if the political process is messing it up, we can't expect the political process to fix it. And so she kicks it to the state legislatures, like, we need you to get in the game here, either through bipartisan state redistricting commissions or state courts or state legislatures, and you, the people, need to be vigilant about this. And there's been some movement. So a North Carolina trial court, a three-judge trial court, said that in North Carolina, more had to be done to draw the districts more fairly, so that is terrific. But this is a really significant decision, if only because withdrawing federal oversight, federal court oversight, means that the political process in the states is basically up for grabs. And I think that's huge, and we're going to see how that shakes out in a lot of different ways.
Okay. Well, I'd like to turn next to conflict among the members on the court. Yeah, I know. And that was widely on display last term around the principle of stare decisis, which Justice Kagan has explained as the special care we take to preserve our precedents. You and your podcast co-hosts call it something a little differently. You say stare decisis is for suckers.
We don't say that.
Well, that was how you characterized last term. Stare decisis is for suckers. What does that even mean? And why do you say that?
So we also started this podcast because we don't believe that to opine about the Supreme Court, you have to be neutral. I mean, like, the Supreme Court prognosticators all kind of talk as though they are going to be on the Supreme Court, so they can't say anything controversial. We have not taken that position. Like, I wrote an article called Marriage is Punishment. I'm not going to be on the Supreme Court. So I'll say whatever I want. Last term, the whole principle of stare decisis, which is a bedrock of the Anglo-American legal tradition, really seemed to be under pressure from various members of the court. So stare decisis, let the decision stand, right? Extant decisions stay in place and you follow them. There were so many points in this term in the court where the court either seemed to be oblivious to prior precedent or seem to be interested in kind of divining an entirely new way to think about stare decisis. And I think the person who is perhaps principally interested in that latter project of redesigning what stare decisis means is Clarence Thomas, right? So Justice Thomas, in a really interesting concurrence in Gamble versus the United States, Gamble was a case about whether the double jeopardy provision about separate sovereigns could stand, stare decisis issue. Separate sovereigns continues to exist, so they upheld the question in Gamble, but Justice Thomas writes separately to talk about this whole question of when the court should follow extant precedent. And he says that the court, where there is a demonstrably erroneous precedent, the court should have no obligation to follow it. In fact, the court's duty is to correct that demonstrably erroneous precedent. Now, what he doesn't say is, how do we know if something is demonstrably erroneous? And based on the opinion, one can only assume that it's demonstrably erroneous if he and 4 other justices think it is.
Well, let me push back a little bit.
Okay.
All right. Oh, okay.
This is in conflict. Constitutional conflict.
I'm going to ask, I mean, what about, just to play the devil's advocate, or just to push back, I mean, let's think about Bowers versus Hardwick, and then Lawrence versus Texas. I mean, Lawrence, which came down the pipe, Bowers versus Hardwick upheld a Georgia law outline homosexual sodomy. And Lawrence versus Texas said that was wrong.
17 years later.
Yeah, I mean, that was with lightning speed.
Lightning speed.
Yeah,
No.
now is that a case of, do you feel better was that demonstrably erroneous?
According to Justice Kennedy, it was.
Okay.
Right? So, I mean, one of the things I think is interesting about Kennedy's opinion in Lawrence is that it really does follow these factors for determining when to overrule a case that are laid out by the court in an opinion, a plurality opinion authored in part by Justice Kennedy along with Justices Souter and O'Connor in Planned Parenthood versus Casey in 1992. So they lay out a list of factors in Casey about when you can overturn something because, of course, the big issue in Casey, should they overturn Roe? And so one of the factors that they consider is, have people relied on this decision and living their everyday lives? And in Casey, it was assumed that women had relied on the fact of Roe in making plans for themselves and living their lives. Was the decision decided under facts or legal information that was incorrect, and since it's been discovered to be incorrect? And in Lawrence, for example, one of the things the court says was incorrect about the way Bowers was decided is that they had not fully appreciated that the law prohibiting sodomy was purposely aimed at gay people in the 1970s, but historically, laws prohibiting sodomy had not been aimed at same-sex sexual contact, but rather had just been about prohibiting non-procreative sexual contact. So to say that we had this long-standing history of prosecuting same-sex intimacy was demonstrably false, because we had a long history of prosecuting non-procreative intimacy, but not necessarily about sex between two people of the same sex. So that's part of what Justice Kennedy was talking about. There are a list of other factors in Casey. I think there are 5 different factors in Casey. General attitudes, things of that nature, whether it's clear on its face, a whole list of different factors. And in Lawrence, Justice Kennedy relies on some of those factors. What I think is really different about this moment versus the moment in Lawrence is that Justice Thomas is unabashed that he doesn't care about the factors in Casey. And in fact, Casey comes up repeatedly in his opinion in Gamble as maybe we should be looking at this. So he doesn't believe in the analytical process that Casey lays out. If you want to overturn something, it's not about going through these 5 factors. It's about just deciding if it's demonstrably erroneous. And if that's the shift, which I think is a pretty sizable shift, then we're not just throwing out Casey, we're sort of throwing out the collective wisdom of legislators, of judges at lower courts, of your colleagues on the court, in favor of what 5 people think is demonstrably wrong. Right? Leave aside the people. Right? So I mean, and I think that's significant. So that would be my pushback. But you're right. Lawrence, I mean, is a sea change, and it's a very quick sea change, and it overrules a case 17 years after it was decided.
Yeah. Well, what about the fact that with Gamble and Justice Thomas, I mean, he's all by himself.
He's always a lot.
He's frequently by himself.
Often alone.
He is. I mean, should we be so worried if it's just Justice Thomas and we know he tends to write just for himself?
So, yes, I think we're worried. I mean, Justice Thomas is famously a kind of lone wolf. He believes what he believes it deeply, he's really committed to it. And it's okay with him if no one's on board with him. But I think what you have to watch is that what seems off the wall today might be on the wall tomorrow. I mean, and part of what I think Justice Thomas's role on the court has been is to widen the Overton window of what is acceptable and what's on the wall. So, I mean, he says it now, and it's like, that doesn't make any kind of sense. But 5 years from now, you know what? Maybe we don't need an administrative state. And it's suddenly on the wall. And here's a perfect example of it. In this term, he wrote another separate writing in an abortion case called Box versus Planned Parenthood. It was a case about 2 Indiana abortion restrictions. The opinion he wrote basically equated abortion with eugenics and sort of cherry-picked history to link abortion to the eugenics movement of the 1920s and 1930s. And no one signed on to it, right? And historians, including the historian he cited, came out and said, that's not quite what I wrote. Like, that's not exactly what my history says. So there was wide pushback, even from the punditry, about this opinion. But I think his point in writing it was to respond to those who have argued that the current logic of abortion restrictions, like this is for women's health, promoting women's health, that has really not been a winning argument, as more and more courts note that in a lot of those jurisdictions that are restricting abortion most aggressively, they have terrible outcomes for women's health. They have the highest rates of maternal mortality. They have the lowest rates of insurance coverage for women. It's not about women's health. It's about restricting abortion. And as more and more people are like, this isn't really about women at all, there needs to be another logic for these restrictions. I think one of the things that he's doing in making this abortion and eugenics argument is linking abortion to the deracination of certain communities, whether it's the African American community or the disabilities community, to sort of create a kind of social justice coalition that is in conflict. And suddenly, maybe it is, if you are someone who is social justice minded, you start to feel a little queasy about abortion if in fact it is a tool of essentially genocide. Right? And so, I mean, I think he's very canny, and he might be alone, but he knows what he's doing.
Okay. Well, speaking of what's on the wall, what's okay down the pike? What are you thinking about? What cases that are coming up in the next term are you going to particularly be watching? And are there hints, about where the court is heading on particular issues?
So some big hot button cases for this term that are coming up. The Zarda case from the Second Circuit about Title VII and whether Title VII covers sexual orientation discrimination is a huge one. That will be enormous. The DACA case will obviously have huge implications, not just for immigration law, but the broader question of executive power, right? That will be important. There are a gazillion abortion cases in the pike coming down. One of them has been pending on cert for some time, June Services. And I think actually that is one to watch because the law challenged in June Services versus Gee is a Louisiana admittings privileges law that is virtually identical to a Texas admitting privileges law that was struck down by the court on a 5-3 decision in 2016 in Whole Women's Health versus Hellerstedt. If the court takes that up, it basically is suggesting that they're willing to think again and revisit Whole Women's Health 3 to 4 years after it was last decided. So I mean, I think that is actually a really huge bellwether. Earlier in the last term, the court decided to stay the execution of the law in Gee, like to allow it not to go into effect. And Chief Justice Roberts signed on to that with the liberals. And like unclear if that meant he was suddenly more receptive to abortion rights or simply was annoyed that the Fifth Circuit had not followed the law in Whole Women's Health or just wanted to avoid the question entirely. But I think that's a really important case coming down the pike. The big issue sort of writ large, I think, are questions about the administrative state. So we saw a number of cases. It's my mother-in-law again.
I know.
She's like, Melissa, stop talking about abortion.
Yeah.
There are a number of administrative law cases from the last term, Gundy, the non-delegation doctrine case, other cases, Kaiser, which involved our deference. I think the direction and future of the administrative state, which sounds totally boring, but the administrative state is so deeply enmeshed in all of our lives, like from the passports you hold, everything is done through agency administration. If we cut out or undermine the administrative state, I mean, it really is a question about can we have a functional government? And I think there are at least 2 people on the court who are deeply, deeply skeptical about whether Congress has the power to delegate its authority to administrative agencies to discharge and whether the administrative state is in fact constitutionally legitimate. And I think that is a hugely important issue that we're going to see more of, if not in this term, then in subsequent terms. And stare decisis.
Yeah.
I think there are lots of cases where things have been teed up, and that has been the hallmark of the Roberts Court. In last term, when Justice Kennedy was the court, there was Janus, which undermined public union membership by overruling a 1970s case called Abood, Abood was in the 1970s. There's a case in 2011, I think, called Harris versus Quinn, where Justice Alito just sort of out of nowhere was like, you know what? You know what's really interesting? Public union membership shop fees. That would be an interesting decision. And he was basically inviting people to file those cases, and they filed those cases. And then we had Friedrich in 2016 during that interregnum when there was no one in Justice Scalia's seat, and that didn't really get decided. But they expressed skepticism about union shop fees. And then last term in Janus, they're like, we expressed skepticism about it in Friedrich, and now we're doing away with it entirely. Abood who?
Yeah.
Stare decisis is for suckers.
There it is.
And I mean, and that, you've seen that throughout, and I think you'll see it again. So I think this term was about table setting. The next two terms is about a smorgasbord of what I don't know.
Okay. All right. Well, I do want to ask one more question.
Okay.
I can.
You're the dean.
I'm the dean.
You own all those books.
Well, you know, the thing that I was thinking about was Chief Justice Roberts has a reputation of being somebody who's very concerned about the court as an institution. And he took a lot of heat. I mean, it was when it was revealed that he apparently changed sides on the case examining the Affordable Care Act. Mm-hmm. And most recently, it turns out that he apparently changed sides again. I mean, it's not uncommon, I'm sure, for justices to change sides and change their minds and making a decision about how to rule on a particular matter. But in the Commerce case, the case looking at whether the Commerce Department could ask a question about citizenship on the coming census, apparently the Chief Justice changed sides again. Mm-hmm. So I guess I'm wondering, is he in sort of what kind of position is he in? I mean, when you consider somebody who holds himself out as being an institutionalist, I mean, who famously said there are no Obama justices or judges, there are no Trump judges, there are U.S. judges. Mm-hmm. How do we square that with this approach to stare decisis? I mean, the fact that the non-delegation doctrine would be up for grabs potentially is kind of amazing. I mean, I thought this had been decided in the 1930s.
It was, and reaffirmed in Whitman not too long ago. So if you've read Joan Biskupich's book about the Chief Justice, you get a lot of color about Chief Justice Roberts. And he is a rock-ribbed conservative, but as Chief Justice, I think he's very different from how he would have been in a counterfactual where he'd been appointed as an associate justice as he was first nominated. He was first nominated to replace Justice O'Connor, and then Chief Justice Rehnquist died, and he took Rehnquist's spot, and then Justice Alito was nominated to fill the O'Connor seat. He's very different, I think, as Chief Justice because he feels himself to be, and I think rightly so, the steward of the court's institutional legacy and legitimacy. And I think he deeply, deeply is committed to that. You saw that in the Affordable Care Act case. I think you saw it this term in the Department of Commerce case, the census litigation. Side note about the census litigation, why was the Department of Commerce so eager to shift to a citizenship-based census model? I think part of it goes back to Rucho. If you switch from population-based census to citizenship-based census, and then you draw your districts based on the number of citizens, you actually shift political power from urban enclaves, which traditionally have trended Democrat, to rural enclaves, which traditionally trend Republican. So there's a connection between Rucho and the Commerce case. And this is all explained by the Hofeller hard drive. So Hofeller is this Republican operative who died, and his estranged daughter came into possession of the hard drive of his computer, where he basically had just a cache of documents laying out the connections for gerrymandering, the connections to the census question. And this was all in the public discourse being reported on as the court was hearing after oral arguments on the census case. And I think part of why Chief Justice Roberts changes his vote, and if you read the opinion, it's very obvious that he changes his vote because the whole opinion initially reads as though they're going to defer to the Department of Commerce, and why this is the one time they're going to defer to an agency, but it's going to be for the Department of Commerce on the census question. And then suddenly it shifts, and he's like, okay, you need to find a better, less pretextual reason for why you want this question. I think Chief Justice Roberts recognized that having that information out in the public discourse about the Hofeller files, about the sort of larger concerted strategy to sort of shift voting patterns and to shift political power, was just a really bad look if the court upheld the Commerce Department's stated aim of imposing a citizenship-based census question to track Latino voting and to ensure that the Voting Rights Act was working for Latinos. I think he recognized that it just was not going to fly, and it was going to really expose the court to ridicule, to calls of illegitimacy, especially after a term where the confirmation process of a justice was so widely publicized and so damaging to the court. I just think he didn't have the stomach for it, and rightly so. Another census case was, of course, at the district court in Maryland, and this was the one with the constitutional issues, not the administrative law issues, and the Hofeller documents were all a part of that. So an interesting place where what is happening outside the four corners of the record really does, I think, impact the court. But I think Chief Justice Roberts is an institutionalist for the most part. That doesn't mean he doesn't stick to his conservative principles, because we saw this year. In the Gundy case, he is part of that so Gundy was decided or was argued before Justice Kavanaugh was seated, so it's only an 8-person court when Gundy is decided. And 5 justices, the 4 liberals and Alito, sign on to uphold the non-delegation doctrine. But Alito writes a separate writing where he says, this isn't the case to strike down the non-delegation doctrine, but if there are others, I'd be willing, I could eat, that would be great. And so he's inviting regulated industries to bring more challenges. But I think his vote is Alito's vote in that case is really strategic. He signs on with the 4, and that provides that 5th vote. He gets to write a separate concurrence, and he also gets Chief Justice Roberts on the record with the other 2 conservatives as being ready to strike down the non-delegation doctrine. So I think that Alito vote was one of the most important votes of last term.
Okay. All right. Well, it's now time. I want to open it up to you all. What questions would you like to ask Professor Murray about what we've discussed or other things, questions that you thought I might have asked but didn't ask? Yes, Rana.
So I'd like to take you back to your comment about Justice Thomas being on his own and look at another case in not an administrative area, and that is the American Legion case. Yeah. And it's a case, obviously, about the validity, if at all, of the approach that the court has typically taken in the Establishment Clause area. And he is the only justice, historically, who has taken the position, historically, that the Establishment Clause does not apply in the federal does not apply in the to the states, and that it was never incorporated into the 14th Amendment. Do you see that approach now being embraced by other justices to change the direction of Establishment Clause jurisprudence?
That's a great question. So the American Legion case is about this enormous cross in Maryland by the highway that was meant to honor, I think, World War I or World War II World War I veterans. It was actually interesting because I think you get a number of members of the court who I think otherwise would be very attuned to the idea of the government endorsing a particular religion, signing on for this cross. And the distinguishing feature is the cross is old, right? It's just been there for a long time. It doesn't really carry the same meaning. I'm not sure I buy that. And I actually think maybe Justice Thomas might be right to be skeptical of that as well. I'm trying to remember how that case lined up, but he does get someone else is with him on that, which suggests that he at least has someone who agrees with him to be skeptical about this particular reasoning. But I'm not sure if it's because they are agreeing with Justice Thomas's view of incorporation, or more that the way the majority has drawn this distinction between old crosses and potentially new crosses is legitimate or viable. I think it's really the latter more so than...
At least in what they've said so far,
Yeah.
it is the latter.
I think
I don't think that's established in this case.
Was it Cavanaugh who was
Well,
with him?
Cavanaugh says he doesn't think Lemon is valid at all,
Right.
period. But Kagan is torn on whether or not it's the age of it.
Yeah.
Breyer says specifically it's only because of the age. And Alito doesn't really say how he would come out, except that in his facts, he talks about that it's old.
Yeah.
So,
I think it's more the rationale. Like, I don't think anyone buys that the Establishment Clause comes into effect only if something is new or newfangled, as opposed to something that is older and more established, so to
do
speak.
you think he'll win more votes in the future as a way of circumventing some of the restrictions that we've seen up to date?
I will say that I don't think he is as alone as he was. I will say this is a great term for Justice Thomas, because they were talking about him retiring at the end of this term, but you know, he has new colleagues, his job satisfaction has gone way up. He's not in the minority anymore, and I think there may not be people who are willing to go to the same extremes as he is, but he has more of an intellectual community on the court than I think he has had in a while.
Thanks.
Other questions? Oh, way in the back, is there, yeah, great.
Thank you. We talked a little bit about National Federation of Independent Businesses, I think. And there was some criticism at the time that while Roberts, oh, sorry. That's terrible.
Who has died?
Cokie Roberts.
Oh, Cokie Roberts? Oh.
The National Federation, sorry, that in upholding of the Affordable Care Act under the power to tax, Roberts laid out the path for making the act unconstitutional. And I wonder if you see in Rucho that Roberts also wrote the potential for challenges to non-legislative attempts to mitigate gerrymandering being struck down by the courts.
I don't know if it's so much in Rucho, but Justice Kagan kind of highlights this in her dissent. You know, Chief Justice Roberts talks about, you know, there are other ways that the political process can address the issue of political gerrymandering without the courts getting involved. You know, state legislative, bipartisan commissions, redistricting commissions, all of these different solutions. And she then notes that Chief Justice Roberts, in a case from Arizona a few terms ago, seemed to call into question the constitutionality of bipartisan redistricting commissions, and she's sort of like, you know, what gives? Like, we weren't sure that this was even okay before, and now suddenly it's the answer because the court can't wade in here. So I think he does some of that. He definitely does it in the commerce litigation, the census litigation. And I think part of that is because this was an opinion meant to uphold the Department of Commerce's decision to add the census question, and then at the end, it turns into an opinion striking it down. But he basically sort of lays out, like, there are all of these things that the department can do to add the census question. It's perfectly fine. And then there's sort of this abrupt pivot where he's like, okay, don't make it quite so pretextual in the future. Go back and find a better lie to support why you want to have a citizenship-based question. So, I mean, there's some guidance being offered and a lot of public signaling from all parts of the court. Kagan is signaling to the people. Alito is signaling to regulated industries in Gundy. Thomas is signaling to social justice communities in Box. And I think Chief Justice Roberts is also signaling there, too.
As you can see, I'm one of the older people in the room, and that means that I'm very much focused on my grandchildren. So I have 3 grandchildren that reside at Columbia University with their parents who are both on the faculty. And when we get together at holiday times, treasured holiday times, recently, guess what worries them? Big capital T, worried about the future of our country with the current political strife and who's in office. And I said, don't worry, whether it's 4 years or 8 years, whichever it turns out to be, that it will be the judicial branch of the government that is later written in the history books as the hero, if you will. Now, am I totally in la-la land, or are the federal courts performing a function with greater volume and intensity of all kinds of different challenges happening. One branch of government tries something and somebody sues them, and it's this huge chess match. Am I in la-la land, or is that going on to a greater extent than, say, in prior 3 presidential administrations? And will the judiciary branch be the hero?
I love your optimism. I don't want to mute your optimism, but I'm going to.
That's okay, because I love to speculate, and it could be this just a bunch of BS that I'm throwing at my grandchildren.
No, so let me say this. So I think the judicial branches have stepped up in a lot of litigation. So with the travel ban, for example, it was district courts with nationwide injunctions who stepped in to open the borders again. The Ninth Circuit, the Supreme Court upholding the travel ban, but there were a lot of work. There's a lot of work at the lower federal courts
Fighting
to deal
over
with
tax returns, there's just all kinds of stuff.
all sorts of
going on.
things, like lots of stuff going on. Let me sort of flip the coin a little bit. This administration, more so than any administration at this point in its tenure, has appointed more judges to the bench than any other, right? So full stop. They've done the best job, A+ for appointing judges. They have done so in the absence of a filibuster at the Senate, right? Which means that they just need a simple majority, right? Which means that the judges that are put up can be as extreme as they want to be. There is no impetus to be conciliatory to the other side of the aisle and put up more moderate judges. There's been some compromise because of Senate privileges and home state senators having blue slip approval and whatnot. So there have been some compromises, but for the most part, the judges being appointed are more conservative, more male, less diverse than we've seen in the last 15 years, right? And we may not see what that looks like in terms of judicial decision-making right now, although I think we're beginning to see inklings of it going forward. Certainly in the Fifth Circuit and in the Sixth Circuit, where Cincinnati sits, we will certainly see the ramifications of that going forward. I don't know if the federal judiciary is going to be the hero. I don't know if we are in the Warren Court era. I think we are more likely in the Gilded Age era. I don't think the Supreme Court has been this conservative since the Gilded Age. I think that's an empirical claim that I'd be willing to back up. I think if we want to look for heroes, we have to think about all of the different constitutional actors here, and I'm thinking about Congress and the Senate. We're in the middle of a presidential primary where no one will talk about the courts and what the plan is to win the Senate, or even to get more membership in the Senate so you can force more moderate judges if that's what you want. We aren't really focused on state government, which to me is baffling, right? I mean, it's one thing to talk about the court protecting reproductive rights. You could also talk about not letting those laws get passed in the first instance at the state level. I mean, or having governors veto them when they are passed. I mean, there's so many different entry points for heroes. It doesn't have to just be the courts. And there's so much, I mean, if you want to talk about the political process resolving some of this, all of us being involved in this. And that's why we have this podcast. Everyone needs to know what's at stake, what the court is doing, because we can't count on the court to save us, I think. We have to save ourselves.
Professor Murray, thank you so much for your time. You all kind of have already touched on it a little bit, but with some of the abortion laws and some of the cases that are going to be heard in this next term, there's kind of some speculation and rumblings that it's a conservative, concentrated effort to overturn Roe v. Wade. And I don't think that's, a ridiculous speculation at all. So my question to you is, what do you kind of see as the process for what this might look like, and maybe a potential outcome for this? And I'm presuming it's not going to be this year, but over the course of the next 5 years that, we'll hear these cases.
So let me first say that the change in membership on the court has certainly galvanized some elements of the pro-life, anti-abortion movement. And sensing that there is a 5-justice majority, they're not sure, but they suspect that there is a 5-justice majority, they have moved to pass more restrictive abortion regulations. You've seen this in Ohio with the heartbeat law, Alabama's law, Georgia's law. it's been very aggressive. It has actually inspired a lot of conflict within the conservative movement because there are many in the anti-abortion camp who would prefer and have been hewing to a more incremental approach, like steady, just chipping away, not really calling the question on Roe, in part because they feared that they did not have a majority at the court and that if someone did strike down this legislation, Ruth Bader Ginsburg would write the opinion and she would write something sweeping about abortion. Right, so they've been very focused on an incremental, just chip away. The laws aren't super restrictive. They're not terribly aggressive. They look reasonable, right? That's not where one branch of the movement is now. Sensing this 5-justice majority, they're ready to move and to call the question on Roe. And I think there is actually some conflict within the right about what the best path forward for overruling Roe is. Is it incremental or is it a frontal challenge? I think part of the problem is Chief Justice John Roberts. Nobody really knows what he's going to do. Is he going to be an institutionalist or is he going to be a rock-ribbed conservative? He was with the dissenters in Whole Women's Health. He would have upheld the 2 challenged Texas laws in Whole Women's Health. So it seems obvious that he's not necessarily, he's not hostile to the prospect of restricting abortion. Unclear if he's hostile to the prospect of overruling Roe. Nobody really knows. What does it look like going forward? I think there could be a frontal challenge to Roe. All of these laws have been challenged and they're making their way up through the lower federal courts and will get to the court. I think unclear whether the court will take cert on any of them. I think it's likely that Chief Justice Roberts will not want to take cert and overrule Roe in a case that is so extreme, like one of these heartbeat laws or one of these criminal bans that essentially has no provision for health or rape or whatnot. I think what is more likely is what the court has been doing all along, which is to say, it has basically hollowed out the right that was articulated in Roe. I mean, everyone keeps talking about Roe. Are they going to overturn Roe? Roe is a non-entity for most women in this country. Like, unless you have private insurance and money and the means to travel and take time off your job and have someone to watch your kids, you can't get an abortion in this country. I mean, you just can't. For most women in this country, Roe is effectively a non-entity. It's a nullity, right? So you've basically overruled Roe in effect, if not in name. And I think we can continue to see that. And I think that's probably what would be more palatable to someone like Chief Justice John Roberts going into 2020, an election year. To strike down Roe in this moment would be to galvanize the 72% of Americans who believe that the Constitution supports some kind of autonomy right to abortion. They may differ on how it should be restricted, but they believe that there is a right. That would galvanize and prompt incredible backlash that would certainly play out in the political process and in electoral politics. And I think he doesn't have the appetite for that. But make no mistake, that doesn't mean that reproductive rights are assured or safe. I mean, like, you can just continue to hollow it out, chip away at it, even without these other assaults. And I just think you're going to see this conflict between the incremental approach and the more aggressive approach on the part of those who sense 5 votes and want to move quickly.
I guess mine's more of like an opinion about the whole concept of, well, I mean, most of these justices, let's face it, they come from a lifetime appointment. But when they get in there, let's face it, you're in that ultimate lifetime appointment. So do they often, you see like Justice Kennedy and maybe even some level of Roberts, they drifted a little more towards the other way. Is there some level of that you've heard of?
So Andrew Martin, Kevin Quinn, and Lee Epstein, who are political scientists, have this index. It's called the Martin-Quinn Index, where they basically track judicial behavior over a period of time on the court. And they, based on their data, say that justices do tend to drift to the left, become more liberal over time. And the paradigmatic example of this is John Paul Stevens, who was appointed by Nixon to incredible fanfare from the Department of Commerce, from the Chamber of Commerce, but then becomes a lion of the liberal wing of the court. That could happen. I think what we are seeing, though, in this moment is justices being nominated to the court at a much younger age than we've seen before, and who are more ideologically to the right than we have ever seen before. So Justice Gorsuch, in the comparison with Justice Scalia, he's actually much further to the right of Scalia, if that was even possible. I mean, Scalia is sort of a lion of the conservative movement, but Justice Gorsuch, at least in his views on the administrative state, is actually further to the right on that. And Justice Kavanaugh is much further to the right than his old boss, Justice Kennedy, whom he replaced. So I think if there is a sense of juridical drift, we're drifting from much further right than we were before. So, which is to say, maybe we wind up in the center, but I don't think you wind up with a Justice Stevens.
Yes, I think it was over the weekend, the news of Cavanaugh. I guess another woman came forward alleging sexual misconduct on his part, and I was wondering, do you think that he will be impeached?
No. I mean, it's the same allegation that was made after Christine Blasey Ford's allegation. This was Deborah Ramirez's allegation. And I think the real issue is that the FBI was instructed to conduct an investigation that apparently wasn't as comprehensive as might have been. And now reporters have done more comprehensive digging and have discovered more evidence. I don't think it will have any effect right now, in part because impeachment, just as like impeachment in any other context, would not only require action on the part of the House of Representatives, it would then require a vote of the Senate, where the same people who appointed Justice Kavanaugh to the bench would be the same people voting on his impeachment, on his conviction.
So kind of something I was considering after you started talking about the political gerrymandering sort of being dubbed a political question from here on forward, and sort of piggybacking off the gentleman's question regarding, is the judiciary going to be the savior? 40 years ago, William Brennan writes the New Judicial Federalism article, and in the last few years we've seen, I think, Pennsylvania's Supreme Court strike down political strike down a map based on political gerrymandering. You had a Kansas Supreme Court with an abortion restriction, and even like, I think Supreme Court in Florida even like overturned, for state law purposes, Dober, the expert witness case. And so it seems like the idea of a new judicial federalism got ignored for 40 years, but in the last maybe 5-10 years, it's being sort of revisited. And I think sort of a way to get to the question of, do we expect too much out of the federal judiciary? And maybe we should be, especially with the current situation of a solidified 5-4 conservative majority, outside of court packing, maybe we should be ignoring that as a venue to actually affect change in a substantive way. And I guess I'd just like your comments on that.
It's a terrific question. Should we be looking to state courts as opposed to federal courts? And I think we have this conversation every 20 years. So when I was in law school, we were having this conversation. This was sort of at the nadir of, I think, the sort of modern civil rights movement after the court had decided Lopez, and the Commerce Clause could not be used in ways that it had been used previously for lots of different kinds of anti-discrimination laws. And people began shifting to state court. So the NAACP launched a huge education litigation in state court in Connecticut that was ultimately very successful. All of this, I think, is exactly right. And in my comment to you, I talked about not just state courts, but state legislatures, state executives. We have to think about all of that. Here's one caveat, I think, about the state courts, which mirrors the changing composition of the federal courts. The Brennan Center just put out a report on state courts, which finds that state courts, many of which are elected, not all of them, but many of them, are less representative of the population of the state that they serve than the federal courts. So they are less likely to have female judges and justices, less likely to have people of color as judges and justices, more likely to be overwhelmingly white and male, right? And that's not necessarily adverse to a progressive bent, but it does stand to reason that one of the things that I think happened over the course of the last 30 years in the federal courts that made it perhaps more amenable to some of these questions is that in the 1970s, we had Justice Carter embark on this full-scale reappraisal of the federal courts and a concerted effort to appoint more women and people of color to the federal bench. We have not seen the same kind of movement in the state courts, partly because of electoral politics and the way state level districts are drawn, gerrymandering again, some more. And we haven't had the same kind of impetus or attention to the lack of diversity on the state courts that perhaps is obvious at the federal court level and garners the attention of people in a really systemic and concerted way. But I think state courts are a terrific place to look. And you all are here getting a great education in Cincinnati and in Ohio. I hope you stay here and become part of the local bar, become part of electoral politics, whether at the state level or the municipal level, become involved as judges. Like half of this law school is women, right? Right? And
more than half of the first-year class.
imagine if those numbers were then subsequently represented generationally in the changing composition of state courts, right? So stay here, run for office, run for judgeships, become the governor, appoint your friends, do all of that. And again, I think it's a really important part of the equation. I just think right now, I hope state courts can be an answer. I wish I had more faith that state courts reflected the populations that they serve.
Okay. Well, let's thank Professor Murray for a great talk.